So we're looking at what a corporation is. We know that a corporation is a legal person. There's lots of other sorts of legal persons, rivers, idols, nature, artwork, but we're focusing on the business corporation. It matters because there are key attributes that are attached to legal personhood, and my argument in the paper is that the extent or nature of these varies slightly depending on the type of legal person that a corporation is. There's 4 types of legal personhood, I believe. The first recognised legal personhood, where essentially the personhood is based on an association of shareholders, a very long-standing understanding. I argue, a lot of us disagree, that statutory limited liability forced the separation of shareholders from the corporation. It's recognised in common law, in UK common law, by Salomon and Salomon, and reinforced recently in the Sakona case. The second type, and again, historically based legal personhood, artificial legal personhood, a legal fiction in the sense that it's created by the state and first introduced from canon law into English law as early as 1612 in the case of Sutton's Hospital. The third type, contractual, so it's based on, believed that it's a contractual basis to corporations. Some people think it's just the shareholders, East Auckland official. Others, Blair and Stout and others, would argue that a wider group of contractual parties, but the main point is they see the relationships as essentially contractual and that's what matters. And legal personhood is just a convenient heuristic formula that is used by the law as a convenience for the parties involved, the underlying contractual parties. And then the fourth one, which is actually born from the work of John Armour, Hansman, Krugman, and so forth in the Anatomy of Corporate Law. It's actually quite an interesting one, really, and they talk about corporate personhood not bundling together shareholders, but bundling together attributes and characteristics. So they also use the term convenient heuristic, correct convenient heuristic formula, but they don't see it as the contracting parties underneath. They see it as these attributes and characteristics. And personhood, again, dotted line, they don't see it as otherwise significant. Now, so what type of personhood should we support? I would argue that recognised hasn't really applied since Salomon and the developments in the late 19th century connected with limited liability, the separation of the corporate fund from shareholders. So a company is a separate legal entity from its shareholders. If you hold to that, I don't think you can also hold to legal personhood being recognised. So is it artificial or contractual? It probably has to be, one of the others, because classic liberal economics is based on transactions between participants. So corporations either transact as if they were legal persons, so that's 4 or 3, or they contract as a legal person. So it's sort of one or the other, really. It has to be one or the other that applies. Now, I would favour that they're artificial legal persons. First point, I think more descriptively accurate of what corporations are. So they are separate legal entities from their shareholders. So that's a more accurate depiction than recognised. A company exists from incorporation, doesn't exist the second before it's incorporated, exists completely after incorporation. So even if the shareholding parties or a broader group contracted, no amount of contracting can create a legal person. So something has to happen for there to be a legal person. And that foundational principle, again, that a company is a separate legal entity from its shareholders. Contractual personhood, again, isn't descriptively accurate when you think that actually how do you form a company? Through the process of incorporation. It's not contractually, even though the contractual depiction holds ground. The fourth one, so the fourth one's probably closest to artificial legal personhood, isn't it? With the only difference being really the dotted line. So both 2 and 4 essentially see, if you like, bundling together where you get attributes. So you've either got to say that You've either got to say that a whole lot of attributes get bundled together in this fit for a convenient heuristic, or you've got it, or you can avert your perspective and say, well, actually, that doesn't make a lot of sense compared with saying that there is an artificial legal person and then it has these attributes and characteristics. So it seems an enormous stretch to say that you have a whole lot of attributes and characteristics, and then the law decides that we'll treat all these attributes and characteristics as a legal person. It just seems a bit of a nonsense compared with just saying there is a legal person, artificial legal person, and it has these attributes and characteristics. So I think 4, although it's closer, again, it's a way that they've sort of compromised on saying that it's contractually based to try and kind of fit the reality of what we have, and to try and downplay the significance of legal personhood. So why it matters. So this is the part I'm interested in people's thinking. So the first way I think it matters, so Huntsman and Cruckman's famous paper about the essential nature of organisational law, they talked about the 3 different forms of entity shielding that you can have. And they talked about kind of a spectrum of organisational forms, starting with a partnership. And they talked about partnerships having weak form entity shielding, so the least strong form of entity shielding. And then they talk about companies, corporations having strong form entity shielding. So a form of entity shielding that won't be disrupted unless the corporate veil is lifted or various circumstances arise. And then they talk about complete entity shielding. Now, Huntsman and Cruckman see the corporation as having strong form entity shielding, but I think if you accept artificial legal personhood and that strong line, you'd have to say that actually they have complete entity shielding. And that's perhaps why so rarely is the corporate veil so-called lifted, because really, in most of the cases can be distinguished or explained away, or they're slightly anomalous, at least in our jurisdictions, perhaps not so much in the US. Creditors can't really make a claim on firm assets. Veil is almost never lifted. It's really only when that legal person ceases to exist and the company is put into receivership and put into liquidation that corporate fund crystallises, and then creditors can make claims. So the significance of the existence of the legal person, artificial legal person, is it protects the assets, the corporate fund, whatever we call it, completely while the legal person is in existence. And the exceptions to that are so rare as to be explained away, usually down to other facts or circumstances, certainly in our jurisdictions, perhaps not so much in the US.
So it's corporate entity shielding, not shareholder asset entity shielding.
That's one of the consequences too. But I guess the point is that it's not just strong form, it's complete. So it's a much more powerful, if you like, vehicle than if it was strong form entity shielding. So again, we give these corporations kind of complete, or their corporate fund, the investors' funds, complete protection while the corporation is in existence. And if it goes into liquidation, kind of the corporate person drops away, and then creditors have access to the fund.
Could this not be consistent with the 4th approach as well, just as another attribute?
Oh, definitely. I think the 4th and the 2nd are almost the same. I just think the 4th is a workaround to avoid the reality of it being the 2nd, because the problem with the 4th one, I think, is again, it's just such a stretch to say there's a whole lot of attributes and we bundled them together into this thing that we call a legal person, and we treat it as if it was a legal person. It just seems as opposed to the reality that you create a legal person and it has attributes. So, but I mean, we could debate that one.
And then, like with private ordering, if shareholders, for example, contract around some of the attributes, then do you not end up with a corporation?
Well, I think what it tells us is that there's a lot more open that could happen.
And because that could really affect 4. Well, you don't have the attributes there, so you're not a corporation, and yet you clearly are. But like in the US, I think, for much of the 20th century, you weren't allowed to contract around, for example, having centralised management. So, but now you can. So now you can say Elon Musk, can do anything, anywhere, any time. So, yeah.
So it just blurs the line, doesn't it, between what a corporation is and isn't, for does, as opposed to two, where it sort of is or isn't, you know. So another thing, the point around perpetual. So what does an artificial legal person has? Perpetual. So we talk about perpetual succession and perpetuity, perhaps not enough. And I think Andrew Swartz is doing work on that at the moment. But we talk about operating corporations for the long term. But the point is that we create, or the state, if you like, creates this entity that could exist forever. So it's kind of immortal, and that's different to the fact that it can exist or be operated in the long term. And again, people who favour the contractual approach or the attributes approach, 3 or 4, will talk about, well, you know, you could get by without perpetual succession. But there's a really good paper by Laura McGregor that shows the problems of Scottish partnerships that have separate legal personality and all the problems that exist with that legal form around when partners leave, all those, you know, when people leave, shareholders, partners leave, all those sorts of issues, which is a really interesting paper to show that actually perpetual succession is a pretty key attribute for corporations. And of course, perpetuity does permit that perpetual perspective. So it makes a better type of corporation, the type of corporations that can shift away from the short-termism that say the contractual understanding might encourage based on current shareholders towards the interests of the corporation itself, separate from the shareholders, a more long-term or perpetual conception. And again, why I think that matters is it doesn't solve all the problems that exist with corporations, but it does allow or legitimise what you might call ESG considerations, because it allows corporations or boards to make decisions that they think are in the perpetual long-term interests of the corporation, even if immediately it might cost shareholders. So you might say, if a corporation has the potential to exist forever, then directors have to care about the environment it operates in, the people that it affects, all of that stuff. So it kind of creates a legitimisation of those broader considerations that is much more difficult on the shareholder-based models, where you have to think it's more based on current shareholders. It probably understands that kind of incredible size and scale, helps us understand why that incredible size and scale that corporations achieve, because they're separate. If they're separate from shareholders, and it's just really a fund that operates as a legal person, then they can grow and grow and grow. If you've got a board acting in interests kind of in perpetuity. And it also probably legitimises a form of state intervention, because perhaps the reason that people hold on to 3 and 4 is that even though you depend on organisational law for recognition of legal personhood, you don't depend on the incorporation process. Whereas 2, really only the state through general incorporation can create that artificial legal person. You can't contract to create it. And what the people underneath have done doesn't really matter. It's going through the process of incorporation that matters. But what that does mean that perhaps states, governments in return can place limits or demands on, it pulls them into the public domain, can place demands, restrictions, expectations. They could limit their lives, all sorts of things. It's not the same right. The same rights don't exist. So I think that's the sort of developing reasons why perhaps we should care about the type of legal personhood that corporations have. So I'd be interested, because this is a developing paper. I mean, you may or may not accept kind of my understanding of the artificial legal personhood argument, but particularly if that is the case, why that does matter, or why, if we've evolved to that type of corporation, because we probably didn't start out with that in 1850, it was pretty clearly based on shareholders at that time, then what we might expect, or how we might regulate, or how we might interact with these artificial legal person type corporations.